guys, thanks for tuning back in. This is Mary and then Emily, our marketing director. I'm also part of the marketing team here at Koehler and Dram. And we're continuing our series on helping you guys with your business. Today, I am super excited because we have Wynne Reece. She created Reece Law, and she also created the Creatives Counsel. This is something that you guys want to know about because their mission is to make legal counsel more accessible, to help entrepreneurs feel successful pursuing their dreams. And as florists, you guys are entrepreneurs, and they work with florists a lot and with creatives, so they understand and can speak our language, which I really appreciate as well. Wynne has an amazing background. She started 2 companies, and then she ended up selling one of them by the age of 30 so that she could focus all of her energy on the Creatives Counsel. I was telling her before, she kind of like reminds me of like this Beyonce character who just like is able to get so many cool things done. She's worked with over 700 different businesses and does pro bono work on the side. So I'm just super honored that you were able to join us today to help us, talk about stuff that the floral industry needs to know about. So thank you so much for joining us, Wynne.
Well, thank you to you guys for hosting this. I have you guys on Instagram Live here too, which is what my phone's doing down here. The team over at Koehler and Dram has been so kind to create this programming for their community and for the event community. And yeah, whenever they reach out, my answer is yes, of course, without question. So I'm excited. I'm excited to dive into IP today and answer any questions you guys have. And of course, anybody who's listening as well is welcome to ask questions too.
Yeah, totally. IP, if people don't know what that is, it's intellectual property. And Wynne, can we just quick talk about, because intellectual property seems like a really big topic. So can you just kind of go through like what it is, why we should care, pretend I know nothing, because I know nothing. So bring us through.
Yes, you got it. Okay, so first of all, I also want to say if it gets too loud, let me know. For those of you guys who are listening in, I was in the house, but there's construction that was really loud. So now I'm sitting on the ground on my back porch. So we're just rolling with it today. Okay, so intellectual property has a number of different categories underneath it. We've got trademark, copyright, patent, trade dress, trade secrets. In the floral industry in particular, and I think probably what we'll talk about today as it pertains to your creations, as it pertains to your blogging, to your website, are both trademark and copyright. Trade dress could come into play a little bit. I will say that patent does come into play in the floral industry, but that really has to do with the development of new varietals of flowers. So for today, we focus on trademark and copyright. Trademark is really, broadly speaking, your name, logo, slogan. Copyright is going to be your unique artistic creation. There's a big kind of gray area as it pertains to floral and copyright and what can be copyright protected and how those different like an image of your floral arrangement can be used. So very simply put, we'll be talking about the protection of name, logo, slogan, and then the work that you create, the art that you build.
Great. This is really good. Well, so if a person is just starting out and they're they have these creations, what happens, with photos? Let's just start there.
Yep. Okay. So, all right. There's 2 different genres of photos. Okay. So you've got, as it pertains to florists, you've got the photos that you are taking, that your team is taking of your process. You'll see a lot of time with floral installation that you're taking imagery or video content as the installation is being built. And then you've also got the imagery that photographers capture of your work at events, or your clients capture of your work after they've purchased it. there's different rules that pertain to all of it and where it's used. So one thing that you guys had asked me about kind of before we got started is the use online and in the digital space. If it's on a blog or a website or maybe social media. One thing that is really good to know as it pertains to social media is typically if you're using an image that is already on a platform. So let's say I see we've got Blush and Wynne on board here today. Hi, Janae, good to see you. So in that instance, if I see something that, you know, Janae has posted on Instagram and I love it, and I repost it to Instagram, by Instagram's policies, that's not infringement. Now, if I were to take it and post it on Facebook, that's infringement. If you take it off of the platform, that's infringement. With that said, absolutely terrible practice to not credit who made that photo. I would never recommend that anybody use an image without crediting it, unless you're downloading from a site like Unsplash, where you specifically can do that. So when you're thinking about like your blog or your website, it is good to figure out where those images came from. Sun's creeping in. Sorry, here, nature of the back porch. So figure out where those came from and properly credit them. And you can also talk with the photographer who took them about how they want to be credited. You know, one thing that you guys had brought up that Hippreneur has taught me all about is SEO. And so there may be an instance where the photographer doesn't need to have accreditation immediately under the image, like a tag under the image, but perhaps in the way that you're actually tagging that image on the SEO back end of it, that you're making sure that you properly credit them for that. So I think really when it comes to imagery, it's just having a very clear-cut conversation of where the images came from, how the image creator would like to be credited, and then honoring that. You know, there's always this gray space between what is actually legal and what's the right thing to do. And in the creative industry, when we all pour so much heart and soul into everything that we do, I tend to think that if the kind of moral obligation or moral practice is a little bit more strict than the law, I still tend to go that way because relationships matter, and your reputation matters. And there's no reason that you can't promote your own business while also uplifting the other businesses that help you got there.
So let's delve into that maybe a little bit deeper, because I have a question. I used to work as a wedding photographer too. So when you're taking photographs of, you know, the floral installations or the pieces at a wedding, I know the photographs themselves, you know, legally probably belong to the photographer, but it seems like there's a little bit of a gray area there because you're photographing someone else's work. So can you talk a little bit about like maybe how that gets navigated?
Yes, absolutely. So that is very, very, I actually spent the morning reading different legal articles and case law on this specific topic because I think that it's so important. So there's a debate of whether or not a floral installation, for example, or a floral arrangement is copyrightable. Is that protectable? Now, almost every florist will say that they believe that it is. There's not a lot of case law on this because one of the requirements for something to qualify for copyright protection is its level of fixation. So you got, was it created by an author? What is the originality of the piece? And then is it fixated? So a painting or a photograph, that's a fixed medium of art that's going to stay around for a long period of time. Flowers die, they wilt. So that's where you're looking at whether or not this fixation can apply to a short-lived arrangement. And I do have like, I mean, I have tons of information on this and we can get in, you know, as deep as you want, but what we're looking at is how that applies to that short-lived piece of art that you are creating. Now, the law, and I don't want to like get too into the weeds because no one really wants to hear about specific case law, but I think this is a clear distinction that's important for florists to know. Generally speaking, the courts that have heard cases on this and on the specific topic of floral being photographed and who owns what copyright in that situation, they look at the level of how unique that floral is. So for example, there was a florist who did a cover of a magazine where they did, you know, some custom painted branches out of, you know, an antique blue and white vase, put a little bird in it, and then put some, I think it was cotton branches or something like that in there. Okay, so there's that. And then they compared that to like a standard prom corsage. And they said that the corsage is not copyright protected because it's commonplace and because corsages don't differ significantly from one another. If you look at the actual makeup of the corsage itself, you might swap out a bud rose for, you know, I don't know, a standard rose or whatever, or orchid, but the composition is not that different versus the actual arrangement that was done for the magazine with the painted branches and the bird and the vase. That was unique because that was not a commonplace arrangement. So in the instance of a photographer capturing that, the image itself will belong to the photographer unless the photographer has given over copyright ownership to their clients. However, photographing a unique floral arrangement like that one on the magazine, they likely also are capturing copyrightable content that is owned by the florist. And so they would need to get a release from the florist in order to be safe in dispersing that image broadly. That also goes into fair use. Okay, so if let's say that you're going to, sorry, I don't even know if my Instagram live is on anymore. Guys, I'm so bad with technology. Oh, my live video ended
all the time.
We had the same issues this morning.
Okay, I'm like, oh boy, I'm like, this is just rather unfortunate. If anybody is still there, I'm sorry. I'm bad at technology and I cut you off. But Koehler's posting this later anyway, so you're good to go. Okay, so in this instance, you're looking at like, let's say, let's say Genevieve is doing a big installation. She, you know, she's done a ton of installations lately, like in pica. That's a pretty unique thing. So let's say that I capture that image. If I share that in, I don't know, Minnesota Bride, if it's shared, you know, as a wedding feature, if it's purely for that purpose, it likely is going to qualify as fair use. However, if I, as the photographer, then go on to sell that image to many people or use it for my own direct monetary gain, that is when you're crossing over into the debatably infringing and in violation of fair use of that florist. That was super dense. So ask me whatever you want to piece that apart, because as simple as I tried to make it, I just like heard myself and I was like, wow, that was a lot of law.
No, I think I understand. So basically what you're saying is that, so I create the piece and that is considered like my work as long as it's unique enough of a design that it can't necessarily always be replicated. So like a corsage, there's like kind of a standard way of doing it, unless you do something like ridiculously crazy that's out of the box and, you know, we've never seen before.
Probably like some of like the floral tattoos or the, you know, the bigger wearable pieces that we've been seeing recently.
Yes.
It's not like your run of the mill, you know, prom corsage that people have been doing for, you know, forever.
Right. So corsages, fair game. Installation, something that's unique, is yours and is like your art. And then anyone can take a photo of it, right? But what's going to end up happening is that if the photographer decides to sell the print, like they make a print of it because it's gorgeous and it's beautiful, they technically do not have the rights to do that because they need your permission.
It seems like the tipping point is like where the line is drawn maybe is at monetary gain. Because when you said monetary gain. So if a photographer is using a photo of your work to make money, then that's infringement. Or, I mean, in very, very basic terms, that seemed like kind of where that tipping point was.
Now, like, I'm wondering about, like, the gray area for me would be like a website. Like, so let's say a photographer or a florist is like building up their website because it's important for like everyone's visual. So everyone needs visuals. Where does that come into play? Is that in the fair game area, or is that in the, like, you should have a release form from the florist and from the photographer if you're going to put that on your website?
That typically, okay, so again, this is kind of in the muddled area because it gets into the debate of, is your website there for monetary gain?
Right.
Which it typically is. So is social media, right? Like, you're typically getting into that area. So I would say to have a release from them. You know, usually photographers are going to be more strict about this than florists are. But again, with those well-known florists and where you're really getting into the unique installations or something that might go viral on Pinterest or Instagram or something like that, that's where it would be best practice to get their permission to do so. Now, I say all of this with the caveat that this is a very undecided area of law. The same as kind of cake designs, right? It's typically not the cake design itself that is copyrighted. It's typically the elements of the cake design. That's like why you always see these knockoff of Disney designs everywhere, is because Disney is really hard on cracking down on local bakeries for, I don't know, putting like Mike Wazowski on a cake, right? Okay, so that is where, so we just watched that with our kids. So sorry, it's like a random.
It's great.
Like, I could have said like Ariel or Belle, but like, no, Mike.
I thought you were going for Elsa there, but it's okay.
But that's where you're kind of getting into this area of how is that being used, and different courts come down on this different ways. There actually hasn't been anything where Minnesota is in the 8th Circuit. There's not been anything decided in the 8th Circuit on this. 7th, yes, but not 8th. So again, it's a pretty undecided area of law. However, as a florist, from their perspective, if I create some unique installation or some unique arrangement, or if I come up with, like, you know, I remember years ago, it was like the new craze was to do the open stem bouquets, right? And then the new craze was to tie a whole bunch of silk and willow ribbon around it and let it cascade down. And then it was how you're photographing your bouquets that you're displaying on social media. All of that is intentional on the part of the florist to build out their brand. So I would say that while both parties have an ability to exercise their that both parties have the ability to exercise their rights, the proper thing to do would be to get a release. And now I should also say, this doesn't necessarily mean money exchanging hands, right? Like, you know, it could just be a, hey, I respect you, I see that you did this, and I want to make sure that that is recognized for the work that you have done. So yes, I would say probably in the website and digital world that there is a strong argument for monetary gain there.
So we've gotten this question a couple of times, either from, you know, clients or students who attend the school. And I know, like, are photographers required to share images if it's of your work?
So, not necessarily. I wish that there was like black and white.
I know, it'd be nice if it was just like a cut and dried answer, right?
It would be. It really would be. But no, not necessarily. Because those images are their copyright. And the thing with copyright is that copyright ownership cannot be transferred unless it's done so in a signed writing by the person who created that copyright. So it's unlike trademark, where you could say in an email, I am going to give this to you, I'll sell this to you, we're good to go. That could constitute a written agreement. But with copyright, because the actual registration process is different and there's not as much vetting on the back end, and anyway, things that we don't need to get into, you actually need to have that signed writing by the owner. So, you know, a photographer is not technically, from what I know, obligated to give those images to the florist. Now, the back end of that is that the florist may then say, fine, you won't give them to me, but you can't use them because it's my work. So it's a little bit of like a give and take in that situation, you know, but not that I know of, is there any requirement of that? Usually the requirement, if any, if it was ever disputed, would be destruction.
What I usually see, at least from an outsider's perspective, and then having worked in the industry too, is that, you know, we all know the floral industry is pretty small, and the photography industry is pretty small, and the events industry is pretty small. So it is to, I think, everyone's advantage to build a better working relationship with everyone, and be more collaborative. And I think a big piece of that is being able to share work. So what you were talking about earlier, when you were mentioning that, you know, you tag each other in your posts and you give credit where it's due, and to the photographer, and, you know, if it's the event planner and the florist, and maybe it's the baker or the event site even. So just maintaining that kind of collaborative, you know, let's all work together and get along type of relationship with people. I think everybody's going to be better off in that sense, and you avoid a lot of this sort of like legal back and forth. It's good to be aware of it, but I mean, if you can collaborate with everybody, you know, across industries too, I think everybody's going to be better off.
Yep, I think that's right.
And this is like kind of like a really good segue, because something that I like people do all the time is they do collaborative photo shoots. So they have maybe like they use the Hutton House as the backdrop, and they have a florist and they have a photographer, and they might even have like a bridal shop that they pair up with. And so we have all of these working different companies coming together to create like one look. And how does that work? Like what should a florist know, or anyone should know, when going into a situation like that? Because I feel like it could be all well and dandy and great, like we're all best buddies, but I mean, I've been in collaborations with people where all of a sudden everything falls apart and everyone's mad at each other, and like nothing's like, all of a sudden everything is just off the rails. And I don't want to be like the Debbie Downer of it, but like it's the creative field, like your heart and soul is into it. So I feel like we really we should talk about like what we should know.
So first of all, not a Debbie Downer. Like that's compared to all the questions that I've been getting this last year with COVID and couples. That was a very light and fluffy question. So no Debbie Downer there.
Great. So glad.
And actually, fun fact. So when I sold my wedding business, I was the crazy person that planned and executed simultaneously 5 photo shoots, 5 collaborative shoots, with each shoot with a different set of vendors, all at the same time, but split between Machine Shop and the Ivy. So I'm very familiar with collaborative photo shoots. And I also still shout out to all of those vendors for like believing in my crazy, because that was crazy in hindsight. That was absolutely insane. So in that instance, you know, I always, you know, recommend some type of document. But here's the deal, is when you're dealing with your friends and there has not been any controversy yet, a lot of people don't want to put a document in place because they feel like that changes the tone of their relationship. So in that scenario, what I would really recommend is whether or not it's in an email, or whether or not you actually just build it into your website, like a styled shoot form that people fill out, generally speaking, when you're doing a styled shoot together. And in that form, you can have some of the basics. I would say make the expectations of both parties crystal clear. absolutely crystal clear. You know, model release is really good. Licensing language, ask the photographer what it is that the photographer wants you to be able to use the images for. Because a lot of times parties to a shoot like this have different ideas in mind as to where they're going to use this content. You know, is it going to be for social media? Is it going to be for a website? Is it going to be for some feature article on, you know, a blog that, you know, perhaps you're collaborating with somebody else on? What is this for? And so just clear communication from the outset is going to make things so much easier. And it also makes it easy for, in the instance that you need to say to your friend who's the photographer, like, hey girl, oh, it's been 8 weeks, I haven't really seen many images yet, you know, can you send me these images over? And you just have that in the email chain of, okay, yeah, they had said that they were going to get you, you know, I don't know, 100 images, you know, within, I don't know, 3 weeks of the shoot or whatever it is. That it sets that expectation, and it takes away a bit of the potential need for any confrontation in the future. It also helps to give your team a kind of a backlog of what the agreement is, so that you don't all of a sudden have a team member coming in and saying, which I've seen happen before, saying, well, you were supposed to give me these images, they were supposed to be high res, we were going to use them for, you know, XYZ, you didn't do that, you gave me small images, and it turns into this cat fight, and it dissolves the friendship that was there, that it didn't need to happen to begin with. It was just that there was confusion as to what to expect. So again, I don't know that anybody wants to do a written here, sign my contract, but I'm a big fan of, if you don't have it in emails, it would seem like a very probably tech savvy, which I am not, but like a expedient tech savvy thing to have on your website, the same way that you would have a scheduling link to perhaps Calendly, I'm so excited to do this styled shoot with you. Here's my styled shoot inquiry form, fill it out, have the terms on there, they fill it out, they submit it to you, and then everything is set from the beginning as to what you expect out of each other.
Right. Well, and I mean, we have standards for how we work with brides, like, you know, every bride, like you treat, I mean, obviously you have like a kind of a recipe of how you would treat a bride. And I feel like if you're just like, hey, this is the way I do my, when I collaborate, this is my way. And like, it is what it is. And like, take me or leave me, I feel like I think it's okay. I think it's you being honest and open about like, this is the way I do it. If you don't like it, I'm so sorry. I'm probably not the person for you then. And I think it's okay to say that.
Boundaries are healthy.
Yeah, boundaries are healthy.
So
Yeah.
can we talk a little bit too about, because we've talked about how florists collaborate with other vendors or other service providers, but let's maybe talk about between florists.
Oh,
So
yes.
say that like you create like a design that you were talking about earlier, Wynne, with like the antique vase and the bird and the painted branches, and it's totally unique and something that hasn't been done before. And then maybe somebody else, another florist, like duplicates that design. So do you have any recourse as a designer when you create something totally unique and someone copies you?
You do. And this is kind of where you get into a little bit of that common law that we were talking about before we got started today, Emily. So the copyright ownership attaches the moment that you create it. And what you get at that time is you get common law ownership rights. Now, common law, very simply put, common law just means not registered. That's what it means. So for common law trademark, as soon as you start using a name or a slogan or a logo, you have common law rights to that trademark. Copyright, you have common law rights to the copyright as soon as you put together that installation. So what happens at that point is, if you see infringement, then you decide if you're going to send a cease and desist. Okay. And now I say that like hesitantly, because it's again one of those lawyer like terms that people are like, oh no, I don't know what you mean, you know. But it is important because you're enforcing your rights. Okay. So there's different ways to go about this. And let me also draw a distinction that so copyright ownership attaches with first creation. Trademark registration is key, because if somebody else is using one of your trademarks and you have not registered it and they register it, they will get primary rights to it. So they may not be able to stop you from using, let's say, your name in Minnesota, but they can say you now can no longer use your name anywhere outside of Minnesota because I filed for the federal trademark first, and therefore I have priority over you, and now you can't use this outside of your immediate geographic location where you can prove prior use. Copyright is different. Copyright, the minute that you create it, you have ownership to that. And if somebody else were to try to duplicate it and to file for copyright for that and to claim ownership of your original work, there's all sorts of trouble they can get into. That's like grounds for criminal action. Okay. So in this instance, the other backside is that with copyright, if you aren't registered, you can't actually pursue legal action beyond a cease and desist. So like you couldn't actually start a suit. So if you have something and you say to someone, no, you have to stop, I have copyright to this. If I'm their lawyer, I'm going to go look up and see whether or not they have it registered. And if they don't have it registered, I'm not really going to be too stressed out about that, because in copyright, if you do not register within the first 3 months of the creation of the work, you have to literally prove damages, which is a massive lawsuit and tens of thousands of dollars. And almost everyone knows that a small business cannot do that. Okay. So if there's something that you create, like an installation that you're passionate about, I would say to file for that copyright right away. Because if you register it within the first 3 months, you can qualify for statutory damages. Again, this sounds very dense, but you can qualify for automatic damages and attorney's fees. And that can be up to like 150 grand per instance of infringement. Okay, so really important to file if there's something that is unique to you. Now the cease and desist. Okay, here's where we end up again in a little bit of our unique scenario of being in a small creative industry, huge creative industry, but boutique in size when it comes from business to business. We're not like, Target sending a cease and desist to Best Buy. So if that were the case, I can guarantee you that it would be one heck of a cease and desist, and you get it and it would kind of be like a punch in the face. Okay, it would be brutal. You'd want to just, I don't know, get some Oreos and curl up on a sofa and pretend you never saw that ever. Okay, but the issue in the small business boutique realm is that you have, again, you come back to your reputation and you come back to what is worth fighting and how is it worth fighting, because is the person on the other side going to, instead of fight you back, make your cease and desist public and make you out to be a monster, even though you had every right to send that in the first place. So with small businesses, when it comes to infringement like that, I typically, unless a client feels otherwise, I typically start with, hey, let's start with a soft kind of almost Minnesota message. Like, hey, I don't think that you knew you were doing this. Totally respect that. But you did do this. So I need to ask you to stop because I have to protect my business just like you would protect your business. I would say that that actually works a good amount of the time, because if you have that fear of negative PR, so did they. Okay. Now, when that doesn't work, then it usually gets kicked up a notch to, like, we'll ghostwrite an email that if they were to show that to a friend or legal counsel or something, that person is going to read that and be like, oh, they've involved a lawyer. Like, this doesn't sound too intimidating or aggressive yet, but there's enough in here that I know that they've involved a lawyer. Okay, that step works probably 80% of the time. If that doesn't work, then you go to the cease and desist on letterhead. And you take it from there, right? So you can decide what you want to do at that point, depending on if it's trademark or copyright, if you're registered or if you're not. You know, I've had some situations where people would like to send that heavy hitting cease and desist and just demand that they stop altogether. I've also had some scenarios in which they, you know, perhaps and part of their brand is supporting other small businesses, and the person infringing actually has great style, you know, and it's just unfortunate that they're infringing, but you still appreciate their business. And so in that situation, you can see other options get worked into that cease and desist, like, hey, if you don't want to stop, I'm open to discussing licensing rights. I'm open to you paying me a fee to license this, or you paying for this image, or whatever it is. So in the instance of infringement, I always say, whoever your lawyer is, contact them first, because every word that you put into a message, even if it's a DM or a comment on Instagram or, you know, an email, even a phone call, it all matters when it comes to intellectual property law, because it's governed at a federal level. And I mean, if you know me, you know that I will tell you that in every version of reality, every word matters when it comes to the law. Okay, I accidentally sent a text the other day to some judges that I know, and it was meant for my dad, and it was about my dad and a situation that we were dealing with at work. And like, I was destroyed, you guys. I'm like, oh my God, they think I'm crazy. They have no idea. This is making me sick. Like, because taken out of context, it could mean anything, right? So then I like went into explanation. My husband's like, Wynne, they probably didn't even think twice about it. And I'm like, I know, but like, holy cow, you know, and then I'm like sick, and oh, it was just brutal. But that's where like every single word matters, but particularly with intellectual property, because you don't want to suggest that your work is descriptive, is generic, is commonplace, that you're going to allow usage, because all of that can inadvertently give up the rights that you might otherwise be entitled to.
I'm just processing. That was a lot.
I know, it's a lot to unpack. It's all really good.
It's so good.
Say, let's just back up for a second and just say, like, if there were 3 things that florists absolutely must know about intellectual property law or common law, or maybe both, what would those top 3 things be?
Okay, so I would say, first of all, the top thing when you're thinking about intellectual property, whether it's registered or common law, the top thing to think about is what matters so much to you that if you were to lose it, it would harm your brand. That's going to help you pare down where you focus your efforts when it comes to protection of your intellectual property. Depending on what that is, I would say, you know, registering your trademark or your copyright is important. Understanding when it's okay to use someone else's image or work, when that constitutes fair use, which ties back into the monetary gain that we talked about. And then also to know how to handle a situation if you feel as though you are facing infringement. Those are the top 3 things that I would say for any vendor or any business owner or any person who owns any intellectual property. The ability to identify what's important to you and your brand, the ability to identify when it actually is infringement versus fair use, which is a very gray area, and that's why it's good to have a lawyer on speed dial who you can ask that question to, and then how to handle it, which takes into consideration who you are at your core as well. And I will say, I hate confrontation. I have been in some scenarios where I could probably sue some pretty major companies, and I've opted not to. I don't want to go through litigation. It's not worth it for me. However, recently it was brought to my attention that in the last like 2 or 3 years, there's 5 other small boutique firms across the country who are trying to use an iteration of the words, the Creatives Counsel, for their law firms. That is vital to my brand.
Yeah.
In that instance, I hired one of my friends at a heavy hitting firm because I didn't want it on my own letterhead, because then it doesn't sound quite as serious because it's my IP, and had them address it, because it was egregious infringement, like unquestionably so. And that is vital to my brand. I've spent years building that brand. So that is a scenario in which I would opt to fight if I needed to. One other thing though, that I do think is important when it comes to trademark in particular, that I think on most vendors, most small businesses don't understand this, no matter, you know, how much research they've done. It's just so, it doesn't make sense to the common mind. Like, it just doesn't, like, even to lawyers, like it doesn't, it's like, why is it this way? But I think it's really important to understand, especially when you're developing a new brand, or you're coming out with a name for a product, or you are, you know, identifying a slogan that you're going to use, what qualifies as trademark infringement on an existing trademark. And that is, it is not, is there something exactly like that out there? What it is there anything that could be confusingly similar to the consumer? Does the name sound the same, look the same, have the same meaning, or have the same commercial impression? So, for example, the Creatives Counsel, if someone were to go and try to use the name Counsel to Creative People, that would be trademark infringement, because it has the same meaning, it has a version of the same words mixed together, it sounds the same, and we're going after the same consumer. So when you have, investing in a brand build out is so important, and it's also a lot of money. And so I really recommend that before you do that, you narrow down your names and you go through a trademark knockout search, a comprehensive trademark knockout search. This is something that a lawyer does. This is not simply going to the USPTO and searching the test system. It is so much more in depth than that, because it involves other languages, different classes, international classes. It's a lot. And it breaks my heart when I see people invest in a brand that could have been ruled out right away, simply because they read on some blog somewhere that so long as it wasn't identical, they would be safe, which is just not true. Which also goes to the point, please don't believe a lot of the blogs that are out there, even if I've even seen blogs that are written by lawyers who are not practicing lawyers, but who are selling forms. It's a lot of misinformation. And it's, you know, it's different from state to state. That's why lawyers are licensed in different states. I'm in Wisconsin, Illinois, Minnesota. And federally, I really recommend, you can gather basic information if you want to do the research. I mean, I certainly look up WebMD. It's a disaster, but I do it. Don't recommend that to anybody, but I still do it. So it's good to gather basic information, but then when it actually gets time to putting things into action, have a call with a lawyer you trust. It's just going to make it so much better and probably save you money down the line.
Well, and I mean, as Koehler services a 5-state area, and probably, you know, we have visions, grand dreams. So like eventually, this is good. I'm glad you're saying this, because I was wondering the whole time when we were talking about this, is this only for Minnesota, or is this kind of like what we've been talking about as like a national kind of like standard that like everyone understands, and like each state is like a little bit different here and there, but like everything we've been basically talking about is generally like will apply to everyone. Does that make sense? My question?
Yeah. So intellectual property law is governed federally. So for the most part, it will apply across the country. So like, even though I'm licensed in Minnesota, Illinois, and Wisconsin, I can do federal work, copyright and trademark, in other states. Now, this is where it gets into a little bit when you're actually getting to the dispute stage, and where I mentioned earlier that we're in the 8th Circuit, and the only circuit that's ever heard something like this is 7th Circuit. You know, I see lawyers debating back and forth. Well, 7th Circuit means that it's only precedent, which means cases that would be relied upon in considering your case. It's only precedent in the 7th Circuit. The issue there is that, let's say Minnesota 8th Circuit, okay, was to hear a case like this, they would still look at what the 7th Circuit case decided, because they have to take, you know, it's like, it gives you ideas and, you know, how did another court evaluate this? So you do run into differences at the circuit court levels. I mean, different parts of the country are different, right? We see that with politics. They just operate differently. So you might have some disagreements. Lawyers and judges certainly don't disagree on, or excuse me, agree on everything. That's, you know, why you have all of the different levels of the court system. But generally speaking, this would be broadly applicable. As you guys chat, I'm going to move myself back inside because I think that the drilling is done and my computer is getting low on battery and I don't want to cut out on everybody. So I'm going to pick myself up off the ground and I'll move in there, and then I'll turn my video back on.
Okay, sounds great. Thank you so much for joining us. I really appreciate all of your knowledge. We were just chit-chatting real quick on the like pause break, that if you guys have any questions, comments, you want us to talk with Wynne about something completely different that's been on your mind, let us know in the comments. We'll have this video out and about so that people have this as a resource. And we really want to be here for you guys as a resource. So also go check out the Creative Counsel, because there is so much good stuff there. And I think Wynne has done an amazing job to make it really accessible. I know so many entrepreneurs who are always like, oh, well, check out the Creative Counsel. They're like the best. And it's so great. And it's so easy. So if you guys, I know lawyer stuff can be really intimidating, especially if you're first starting out or you're kind of like, oh, I'm in a situation. Go check her out. I will put links in the descriptions below, or if you're on Facebook, it'll be above or in the comments. So like you will be able to find your information that is needed. As always, please like, comment, subscribe. The more you subscribe, the more you like, that shows us that you want this kind of content. Otherwise, you know, we'll just be here talking by ourselves and having great combos. So thank you so much for tuning in. Thank you, Wynne, again for joining us. And from here at Koehler and Dram, we always appreciate our community and helping, you know, people reach their dreams. So thank you so much.
Thank you guys. Have such a good day.
You too. Thank you.
All right. Yeah. Bye-bye.